Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching the miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
Chris, they don't do intensive outpatient anymore. Ridgeway stopped that program. Oh, it's on Ridgeway. Nope, no longer an option. No longer an option. I'm actually still shocked that
I need lollipops too, probably. Oh, people are showing up. We're not alone anymore.
He's coming off.
Oh, let's see what we got. Mr. Cole.
I did on the guy. I got
I
that.
know we can take care of that.
And then, I think it was some sort of break. We're gonna break something about that.
You're not first, sir. You're not first.
Okay,
I just saw you, I've got your name down here now.
thank you, Your Honor. I
You'll go
wouldn't know
second.
what to do if I was first.
That's fine. Good morning, Your Honor.
Good morning.
Your Honor, Chris Garrett on behalf of Austin Clarkson, 22 CF 2055 and 22 CF 550. Your Honor, we set this case with the hope of resolving it today. The offer from the state was for Mr. Clarkson to go to Keaton. He was unfortunately found to not be a suitable candidate for Keaton. We're trying to keep this moving. I think we are fairly close to a resolution here. My understanding is there is a court date on May 23rd at 1 p.m.
So, we can,
And I guess, Your Honor, if there
June
are...
15th is our, well, May 23rd, that's right.
Okay. And Your Honor, are
Is
there any...
that for a regular miscellaneous or for, at 1:30, do they have arraignments on that? No arraignments. How many do we have on the 25th?
For 9 o'clock in the morning, I show you have 6, and for 1:30 in the afternoon, I show you have 5.
Here it says 1:30.
At 1:30?
I'm just wondering whether we're doing it in the morning as well.
9 a.m. and 1:30 chosen.
Okay. It just doesn't, it doesn't say. Just put 1:30. That's all right. I just wanted to make sure.
Yes, sir.
Okay. So you want to do it on the 23rd, sorry?
Yes, Your Honor, unless there are any other court dates between the 23rd and pre-trial that are closer to May.
June 15th, 23rd, and then June 15th.
June 23rd, or I'm sorry, May 23rd, Your Honor, if we do the 1:30.
Okay, very good.
All right. I believe that's all I have, Your Honor.
Very good.
Thank you.
Thank you. Mr. Powell.
Thank you, Your Honor. Thomas Cole is back, and I'm covering for Bo Powell. Good morning.
But I'll go and take the original.
You may proceed with this motion to reduce the law.
Morning, Your Honor. Dixie Dan Powell. I'm covering for Bo Powell, State of Florida versus Thomas Ralph Cole, 2023 CF 851. We're here on a bond, a motion to reduce the bond, Your Honor. And the motion sets forth the charges and the defendant, it's a second-degree felony and a third-degree felony, and we felt that the bond of $150,000 was high. He cannot meet that requirements. He's been employed with the city of Niceville for how long time? 7 years. Lifelong resident of Okaloosa County. His brother and sister-in-law are in the courtroom, Your Honor, and they have made arrangements for Mr. Cole, if he can get a bond reduction, to reside on property they have away from kind of out in the country. But we're asking, I felt it was a little high for this kind of case, although the type of case it is, but it's still a second-degree felony, and $150,000 is pretty high. No way he can meet it. He does still have his employment waiting for him, and we would ask the court to lower the bond and give some type of GPS monitor or whatever makes the court feel comfortable, and release him under pretrial services. So we understand it should be a reasonable bond, but that's one he cannot meet. Steve?
Your Honor, the state can certainly recommend a much lower bond if we have the safeguards in place. The safeguards that we're certainly concerned about are going to be the pretrial services, the GPS monitor, the no contact with any minors, the no internet access or social media access.
Was that included in the I think those were included in
Those are generally standard requests, Your Honor. Let's see if they were
I don't know if we
included.
have to order it if it's already on.
I believe those are in there. It's unclear as to whether or not he can have any contact with any minors. We're asking that there be no contact. Your Honor, with those conditions in place and those safeguards, we believe the community would be safe from Mr. Cole, so we would agree to a bond of $5,000 per count, cash or professional. That would be $15,000 total. He does have a minimum guidelines of 46 months if convicted, Your Honor, and a maximum of 25 years exposure.
The court agreed that on the second-degree felony, I'm going to have it as a $10,000 cash or professional, 5 for the other 2, but importantly, all 3 of them would have the additional conditions. Let's make sure we got them. We got no internet, no contact with minors.
The GPS monitor, Your Honor,
GPS monitor.
and pretrial services.
And pretrial services. Okay?
And Your Honor, where he would be residing, there's only one neighbor, an elderly black couple, no other neighbors, nothing. It's out kind of in a farm, rural area, and he would not have any contact with, be around any minors or anything.
Okay, very good.
Your Honor, the only concern we might have is we're not sure exactly what his employment is with the city. If it does have him in any contact with any minors, certainly they need to be aware of that, and they might have to adjust his employment.
He's on administrative leave now, so I'll check. He may just stay on administrative leave till we get. So we'll make sure those safeguards are in place.
Thank you. Very good. Thank you.
Thank you.
We have several defendants that are here today that are here on violations of probation. It's your first time here. And I showed that there have not been an attorney appointed. So if you are here without an attorney, you do have a right to an attorney, as every defendant does. If you cannot afford one, one will be appointed to you. There may be discussions with the state before that as far as any plea, but I just want to let you know that you will have the right to have, I'll be asking you if you want to have an attorney, or if you're going to hire a private attorney, or if you want to try and plead something out. You have, those are all your options. So as you come down, and just be thinking of that. If you are appointed an attorney, what we generally do, we'll take a plea here today, a denial plea to preserve your rights, and then set it out at the next hearing so that you'll have a chance to discuss it with your attorney. So with that, I'm going to go through a couple of the folks that are listed here that do not have attorneys. Corey Clark. State.
Your Honor, I do not see Mr. Clark approaching the podium. The state would request cases.
For order and no bond capias. Bobby Davenport. You can come down to the podium, sir. Would the state announce the case, please?
Yes, Your Honor, this is 20 CF 2964.
And we're here on the first violation of probation. So, if there has been an offer or a discussion with any of the defendants, unless the state seeks to, unless you all say something, I'm going to proceed and ask him for an attorney. If he wants an attorney, and go ahead and enter it now. If you all have discussed with him, jump up and let me know.
Your Honor, I certainly haven't discussed this with Mr. Davenport, but I will know that the state's offer is for him to admit the violation of probation, for him to be adjudicated guilty, to extend his probation for 1 year and modify it to include Bars to Bed, Keaton, or Phoenix House as a condition, and followed by the remainder of any supervision on community control. Your Honor, I don't know if he knows about Keaton or Phoenix House or community control, so if he wants to speak to a lawyer, he certainly has the right to do it.
So this offer will not be, will be still on the table. So kind of a complicated offer. You do have a right to an attorney. Let's start off with that. You wish to have an attorney appointed? Okay. Court will appoint the public defender. The court's going to issue a denial, and we'll come back.
I don't know. I don't think he has a new law, but I don't.
Come back
He has a new law. Taylor, does he have a new law charge too?
We'll just come back in the morning.
Ryan, it'll be mine because he has a new misdemeanor. I'll give him my card. Oh, never mind, sir.
Seems like this is probably going to be my matter, Your Honor. I'm going to hand him the card.
June 20th, which is 5 days later, you have 2.
Thanks, Taylor.
So
Ryan,
we'll continue this until June 20th in the morning without subpoenas. Okay? Andrew Flannery, he's an inmate.
you want to have the Andrew?
Yeah, I'm doing all the no attorneys, so we'll.
This should be yours on
Flannery? That's a good point. We can do the ones that are without. Why don't we wait? We'll wait on the inmate. Sorry, let's wait on the inmates. We'll do the other ones first. Rebecca Farakis, if I pronounce that correctly. Okay. State?
The state would request a capias.
She's in custody.
22 CF 2327. She's an inmate? Okay. Doesn't show, but that's all right. We'll bring her back in a second. Okay. Justin Hammett. Justin Hammett. State.
The state would request a capias.
Court will order and no bond capias. Daniel Scholler. Daniel Scholler. 2020 CF 72. BOP. State.
What was the last name?
Scholler,
The state-
S-H-O-L-L-E-R.
The state would request a KPS.
Your Honor, just so the court's aware, Mr. Scholler does have a new law violation that's in Division 2. I don't know if he's been transferred over, but I would say he may be confused on his court dates, given he's got 2 cases in 2 different divisions.
He moved off of this docket?
Yes, sir. Good job. Just moved off the docket yesterday.
Okay, so where was he moved to? The other. Okay, so this was done, so the court's going to withdraw the capias because it's on Judge Brown's docket. Okay, those are all the no attorneys that are here. Is there anybody that's out in the gallery that believes they're supposed to be here today? That's some of your cases.
I have at least 2 clients on the docket that are out of custody, Your Honor.
You want to go ahead and do those?
Certainly, Your Honor.
Sorry, clear the court.
First, I'll call Ms. Renee Henricks.
I'm sorry.
Henricks, Your Honor, H-I-N. This is 22 CF 2374. I'm not certain if a denial has been put on the record yet. We'll go ahead and do that.
Hold on.
Yes, Your Honor.
This is not the first hearing, so I'm assuming that there was a denial that was on the record. This is an evidentiary, which just nomenclature means it's been.
Yes, Your Honor. We missed our appointment with Ms. Henricks. I think it was sometime last week. I've been presented with the state's offer to resolve this matter this morning. I'm asking the court to continue this to our next date in June if the state has no objection.
Okay. We'll come back on June 20th in the morning without subpoenas.
Thank you, Your Honor. And the other matter I have that's out of custody, Your Honor, is Ms. Bohannon, but she is waiting in a rather long line outside the clerk's office to make a good faith payment before she came into court today.
Okay.
So I'm asking that we hold off on her for a moment.
Do we want to do the inmates that don't have attorneys? Absolutely. Let's go ahead. All right. Correct. Okay.
Your Honor, while we wait for the inmates, number 10 on the docket, Justin Hammett, my understanding is that he was run over last week.
He was run over?
He was hit by a car. He is alive, but we might want to reschedule this court hearing as opposed to issue a KPS for him.
Counsel, I think that's a fair thing to do. Why don't we,
We're going to have a strong conversation.
but know that he's going to have to be noticed because he's not here. So somebody's got to give him notice. How far out do you think we ought to try and do? You want to do it in about a month, June 20th?
That sounds
Is that
fine.
too late?
Does the court clerk send notice to him?
Yes, sir.
Would they send, okay, you would send it, okay, thank you for,
I will show that he's represented by counsel.
that is correct. I just wanted to make sure that, we don't announce it in court and then he doesn't know about it and it doesn't show up and we try and issue another KPS.
I understand. Thank you.
Okay, very good. So we'll continue this until June 20th without subpoenas in the morning. Thank you for
You said
clarifying that, counsel.
Thank you.
Okay. Ms. Farrakis,
Yes.
would the state go ahead and announce this?
This is case number 2022
sir.
CF
Yes, sir.
002327. It's a violation of probation. The state's offer is 12 months or 12-1 DOC, adjudication of guilt, court costs in the amount of $100 DOP fee.
So ma'am, you do, first of all, you have a right to an attorney with these matters. And because they have a DOC sentence, a prison sentence, you might want to do it. We can enter a denial on your behalf today, and you can meet with your attorney.
Can I speak?
You can, but if
I
I
would
were
like an
your
attorney,
attorney,
but I would like to
listen
know.
to me. If I were your attorney, I would be telling you not to speak. I'm not your attorney, and I'm not telling you that. But if you want to speak, I'm going to put you under oath, and everything you say is going to be recorded and it can be used against you. Do you understand that?
I'm okay with that.
Okay, would you raise your right hand?
Yes, sir.
Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
Mason.
For the first time in my life, I'm asking for this court to have a little leniency on me. I'm just asking that you guys would just allow me 30-day furlough.
Ma'am, let me
Just-
make ma'am, I don't want to mean to cut you off. First of all, you have a right to an attorney. Do you want to have an attorney appointed?
Yes.
Yes, okay. So the court's going to appoint you attorney, okay, the public defender. They're experienced at this. Let's continue this matter until June 20th. Give you a chance to talk with your attorney and
Can you just give me a
whatever you're
bond?
telling me.
Can you just give me a bond on my violation, please? That's all I'm
If
asking.
you want just to file a motion for a bond,
Can we file that for right now?
Counsel, you're being appointed, I don't even know, I don't even know what the bond is because it's not, I didn't anticipate that.
Yes, Your Honor, and just so the state's aware, the VOP in front of the court is actually a misdemeanor, so legally she cannot be sentenced to a 12-1. I think I'd let him know that last week, but she does have a new felony, drug-related offenses, that is set for June the 15th. If we can set this for June the 15th, and in the meantime, I could look at setting a bond hearing that morning as well.
Okay. So is that a new law was on June 15th?
Yes, Your Honor, it's a drug-related offenses, yes, Your Honor.
That's the arraignment on June 15th?
Yes, Your Honor, if the court would go ahead and appoint the public defender, I've already been appointed to that, so I've got that case already.
Okay, great. So the court, on this case, will appoint the public defender, and we're going to continue this until June 15th, and at 1:30, so track with the other case.
Yes, Your Honor. And in the meantime, I'll meet with Ms. Baracus about the bond hearing and see if we can't do that the morning of.
Okay. Counsel?
Your Honor, the offer would be the same offer, but with 1129.
Okay.
So today's no denial, we're just.
Denied, we're going to enter denial.
You can have in the back. Later. I don't talk to you. Got your plan to draft you. You've got other people that want to meet you. Mr. Flannery?
So with the state announcement, please.
Judge, this is case number 2020 CF 001030. This is Mr. Flannery. The state's offers bars to bed, Phoenix House, followed by the original terms of probation and a $100 VOP fee.
So, Mr. Flannery, you're here on a violation of probation. I don't think you have an attorney appointed. You're just anticipating? Okay. So, Mr. Flannery, you do have the right to have an attorney appointed in this case. We can appoint an attorney if you cannot afford one, and we can go ahead and enter a denial so you have a chance to meet with him and figure out kind of where to go. The state's making an offer, you can discuss it with your attorney if you believe that's in your best interest, okay? You wish to have an attorney appointed?
I already thought I had Mr. Gates was my attorney.
That's on your other case, not on the new case, the VOP. Are you on his underlying case?
Yeah, Your Honor, I think this is just a technical violation
Yes.
before the court, which would end up with Mr. Morrow.
Okay, just, they have a little different division in their office.
Yes.
So, Mr. Morrow, but actually, it's the public defender that's being appointed, so it kind of, they've got a team going over there. So you wish to have an attorney appointed? I gotta have to ask you that.
Yeah.
Okay, so the court will appoint the public defender, and the court's gonna enter a denial on your behalf, so you have a chance to meet with your attorney, and we'll come back on June 20th without subpoenas in the morning, 9 a.m.
Can the state announce what they were proposing again? I'll go ahead and get the evaluation out of the way.
Certainly. The offer is bars to bed, Phoenix House, followed by the original terms of probation and a $100 VOP fee.
Thanks, sir.
Thank you.
Mr. Kessinger?
Yes, sir. Andrew,
state announce this is Dakota Kessinger?
Yes, Your Honor, one moment.
Case number 2022 CF 1323. So, Mr. Kessinger, you're here on, well, it's actually a VOP evidentiary, so you've been here once before to make a plea. Do we have a denial on the record? We're unusual not to have an attorney.
Mr. Kessinger said he was going to hire his own attorney last time in court.
Yeah, my family went to retain a lawyer and they decided not to take my case, so we're getting our retainer fee back so we can go with somebody else.
Okay, so you still
Yeah.
want
Yes, sir.
to hire a private attorney?
Yes, sir.
Okay. Do you think it's going to be, okay. I'll continue, you got to move these cases, so, go ahead and try and see if you can get that done. We'll continue it until June 20th
Yes, sir.
at 9 a.m. for that. Okay, thanks. Thank you, Mr. Gates.
Next we have Bednarik.
Good morning, Your Honor.
Good morning.
May it please the Court, Brad Stewart, on behalf of Mr. Joseph Bednarik III, Judge, this is 22 CF 2023. Judge, we left this on today's docket for purposes of status. It's my understanding that the state has some additional discovery that they intend to disclose. Judge, so at this point, if we could have the next miscellaneous date, I need the opportunity to evaluate that as well as with my client.
Okay. June 15th, June 20th, what do you want to do?
June 15 would be fine, Judge.
Okay. We'll continue this to June 15th in the morning without subpoena.
Thank you, Judge. Your Honor, I do have one other matter, non-incarcerated.
Correct? You may.
If I may, Mr. Jesse DeBoard. Mr. DeBoard is present before the court, 22 CF 908. As Mr. DeBoard approaches, we similarly situated, we left Mr. DeBoard's case on the docket for the purposes of status. Judge, if we could just put this, move this forward on the pretrial docket, we are hopeful to bring this into the resolution this cycle.
Okay. So June 12th, 9 a.m.
Very good. Your Honor, that's all I have before the court. May I be excused?
You may.
Thank you, Your Honor.
Your Honor, may I call my other out-of-custody client?
Sure.
Marilyn Bohannon. Ryan Morrow for Ms. Bohannon, Your Honor. This is 18 CF 1079.
What's the last name?
Bohannon.
Bohannon, Maryland. Very good.
Ryan Morrow for Ms. Bohannon. If I didn't already announce, Your Honor, that case number is 18 CF 1079. The defense is going to request that we continue this to the 6/20 date. Ms. Bohannon came in this morning, made a $300 payment towards her financials. The paperwork that I'm looking at shows about another $825 outstanding. And she also asked me to make the request, and I believe the state has no objection, that she be allowed to buy out the community service work that remains, if the court would be okay with that as we approach compliance.
State okay with buying out the...
Your Honor, yes, the state is okay.
Very good. The court will allow that. And we'll come back on June 20th at 9 a.m.
Thank you, Your Honor.
You want to go, Mr. Harper?
Yes, Judge.
Dominique Goodson.
Judge Rudy Harper on behalf of Dominique Goodson. She's before the court on 22 CF 1027 and 22 CF 1019. This will be a plea this morning. Plea to count 1 of 22 CF 1027 and plea to count 1 of 22 CF 1019. The state.
That one got 1019 on today's document.
Yes, sir. For some reason, it shows the other case with Mr. Gates. I think it's 2 below mine. but they both should be with me.
Sure.
I'm not certain as to why I was.
That's all right, no, I'm just trying to keep track of it. So it should both be regional conflict counsel.
Yes, Judge.
On 10/27, the regional conflict counsel has been appointed, not Mr. Gates.
Yes, sir.
Okay, thank you for clarifying.
Yes, Judge. Essentially, she's just playing to the misdemeanors. The state will announce a no process to the felony counts. She'll be adjudicated guilty, be issued credit for time served to run a concurrence, be assessed the court costs. She's asking for 180 days for those costs to be paid or sent to judgment, and there'll be no action on the failure to appear. If I can just have my client sign at the bottom.
Is that the state's agreement?
That's correct, Your Honor. And just for the purpose of the record, on the case number ending in 1019, I think Mr. Gates put in a motion to withdraw. In a point.
Order signing?
I didn't see an order when I was reviewing.
Say that again.
So in the case that's on the docket today, when I was reviewing, I saw that Mr. Gates did a motion to withdraw, but I don't see a signed order. Do we need to take
Is that 10/27?
No, sir, it's 1019.
I've got 10/19 as being Mr. Harper's case.
Yes, sir. And then I have 1027 as being Mr. Gates' case. But then also on 1019, I have what looks like FTA from April 12th.
Yeah, I think we're addressing that this morning with no action.
So
We'll make it easy for the court. This time, we'd ask the court to allow the public defender's office to withdraw all cases that we're still appointed to in Ms. Goodson's case.
court will grant that and appoint the regional conflict counsel.
Thank you, Judge.
No. Thank you. Yes, sir.
This is a plea to just misdemeanors, so there's no score sheet.
Okay, thank you. So the two no process are on the, I'm trying to make sure I've got the records clear. So count one on both of them and count two on both of them are the felonies that are being dismissed?
Count one on as to each are the misdemeanor petty thefts, and then count two as to each are the felonies that will end up being dismissed.
Okay. Question?
I showed it count one on 1019 as a third-degree felony. I need the information.
Good catch. It's, I think the value is such that it makes it a third-degree felony, so are you all agreeing to a lesser included?
That's correct.
Do you have the statute number for the lesser included for the clerk so she can make sure and get that ordered? No.
I can find it, Judge. If it's okay with the court, perhaps we'll pass on this to get that information to ensure that it's accurate, but we'll address that this morning by plea.
Okay. That's all. We'll get this squared away. We'll do this wait with this, hang with us just a little while and then we'll bring it back.
Judge, the next one is Jeffrey Brown. Judge, I spoke with the state this morning, and I think that we're actually going to resolve it this morning, but if we can pass it, because there's just some technical things we need to ensure is correct on the plea agreement, but we'll address it by this morning.
Okay, very good.
Keep it good. Thank you.
That's all I've got for Mr. Harper. So who wants to go, Mr. Gates or Mr. McGee?
Governor, I'm in the process of printing a plea agreement with my out of custody client, so if we can skip mine and just go with
Yes, Your Honor.
Morrow or Mr. Medina.
I have two bond motions ready to go whenever it's appropriate, Your Honor, for Ms. Nina Cox and Mr. Kirby Dixon. You can do those.
Let's do Cox and Dixon.
For Nina Cox, and then after that will be Kirby Dixon.
But I can go after you. Your Honor, this is Steve Medina with Nina S. Cox. We're here on a bond motion. It was filed pro se, but I filed a notice of adoption of the pro se motion, and also with that adoption notice was a filing of her Path of Grace acceptance letter. So mostly what I wanted to do was...
What is the current bond?
The current bond is the no bond on the VOP case, Your Honor. That's 19 CF 1465. The motion was intended to address both cases. So she was asking for reasonable bond on the no bond VOP case, and she's going to want to ask for a bond reduction. And with there's a pretty high bond right now that she's not able to make, and she's hoping to do pretrial services and allow her to go to Path of Grace. Basically, when I talked to her 2 or 3 months ago, she was hoping she could work out her case to Path of Grace for a final resolution. I don't think that's available to the state, from the state's point of view right now. We're waiting for FDL Lee, is my understanding, in the new law case, 22 CF 3023. She doesn't want to talk about the facts of her case, but she wanted to testify about her need for inpatient treatment and so forth. Could she address the court?
Will you please raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, sir.
Okay, speaking to that mic
Yes,
so I
sir.
can hear you. Slide over there. You got to
Miss-
talk right in to pull it down to you.
And Ms. Cox, because I'm your lawyer, I'm going to ask you a few questions, but you know not to talk about the facts of your case, right?
Yes, sir.
Ms. Cox, would you state your name?
Nina So Cox.
Okay. What is it that you most want the judge to know about your situation?
Ooh, I'm not good with public speaking, but I'm going to speak for myself and my daughter.
How old is your daughter?
She'll be 15 September 1st.
No, I think that you were advising me that right now she's gone with your mother-in-law to Idaho to temporarily have some custody. Is that right?
Yes, sir. Just a couple weeks ago she left. I may be a lot of things, but at the end of the day, I love being a mom. And I'm a mom at first.
You're suffering from substance abuse problems that you've had for a long time, is that right?
Yes, sir.
Okay. And why is it that you believe Path of Grace would be a good place for you to be, even while the case is still pending, while you still have charges on the VOP case and the new law case?
I want to put God first, and it'll help me grow my relationship with Him. And the program was going to help. It will help me better myself, learn who I am, so I can be a better parent to my daughter.
And I think you reached out to Path of Grace even before you met with the public defender, is that right?
Yeah, yes, sir.
There was also reference, I don't want to deny you the right to address anything related to your late father's estate. I believe he was a former Marine, is that correct?
Yes, sir.
Is there anything you wanted to tell the court about that, or any other issues that would be benefited by your being out of custody if the court is willing to do that?
I can help. I can get going on the court fees and costs. I know I have a lot of that.
He left me an executive will. I don't know. I know the program would also help me with that. I know Eddie said that he would help me with that. But.
Eddie is the director of Path of Grace, so he's aware that you've got some estate issues with your father.
Yes, and this is in North Carolina, so times of virtue.
If you were given basically a bond with a special condition of Path of Grace, is that what you want to do?
Absolutely. Yes, sir.
Your Honor, I don't think we have anything further.
What are you asking for?
Your Honor, Ms. Cox, is there any amount of cash or professional bond that you can pay at this time, or would you ask for the signature bond in both cases? If there is some sort of bond, it might help.
500. I don't want to ask too much.
You think you could get $500 for, so a total of $5,000 cash or professional?
600.
6,000 cash or professional is her testimony.
Thank you. Counsel for the state.
Yes, Your Honor, I do understand Ms. Cox is in Mr. Medina's possession. However, in the 19 CF case, it's my understanding that the posture of the case is that that is a violation, which a trafficking charge was reduced down to allow Ms. Cox to do drug court. It was a little unclear to me whether she was successful or unsuccessful in drug court. I think it was unsuccessful because it's still open as a violation. And then she picks up a new charge in this new 22 CF case with a trafficking amount of fentanyl. There was Xanax, and I believe the other drug, I'm sorry, Judge, was suspected to be methamphetamine. If you'll give me just a second, I'll confirm that. Yes. I'm sorry, yes, methamphetamine, MDMA, and fentanyl. Your Honor, given the fact that she's already had a reduction and allowed her to do the drug court program, and now we have a trafficking amount of fentanyl, the state's not in a position to agree to any sort of signature bond. The state's not in the position to be able to reduce that trafficking bond, the bond on the trafficking count lower than between $15,000 and $20,000, Your Honor. And that's almost where the bond is for the trafficking amount of fentanyl, Your Honor. So the state's position would be that we're not in a position to be able to lower that bond much or agree to a signature bond.
May I just make one final argument, Your Honor? The twofold. Number one is that I think that the state and certainly the court has a strong interest in her pretrial compliance. If she's in Path of Grace, that's a very supportive atmosphere. She'd be learning life skills, and being in a drug-free environment would be very good. And the number two is that it would help her make sure she kept her court appearances. But I do not think that there will be a problem with her attending in court. Will you attend all your court appearances as mandated?
Yes, sir.
Thanks. Just for the court, I'm sorry, Judge, I said I had my piece, but I just wanted to know, this is another one, and this is not the state's or FDLE's fault. I'm sure they've got a big backlog, but this is a December 4 situation, so it's 6 months, and I don't think we have FDLE in the new case.
What's the status of FDLE?
We are still awaiting the report, Your Honor.
Have you followed up with, we're not just waiting on them anymore, we're going to have to start pushing them.
We are still awaiting the report. We did check prior to the last pretrial, Your Honor, and still do not have a report.
They told you, are they processing it? Usually they give you some interim or something, don't they?
Yeah, I'm sorry, Judge. I did not speak with FDLE analysts, so I don't know the answer to that question, but I will find that out and let
When you
Mr.
come back on the next pretrial, you need to,
No,
when we're
that
having these
information.
lengthy FDLE, we need to get some information on it.
Yes, sir.
Fine, but today we're not preparing, we're here on the bond. Look, ma'am, I'm a big supporter of drug court and certainly want you to deal with your substance abuse. But you're looking down the barrel of a fentanyl trafficking charge. And that is a crisis of huge proportions in our community. We're pulling people off the street every day. The morgue is pulling them off the street based upon that. And so, problem is that the state, apparently their offer, and I'm not suggesting that it's improper in any way, is not looking at some type of a final resolution of this case that would allow you to be on probation at path of grace. So you got path of grace. If you got out on a bond, you have path of grace, and then you're gonna what? Either go to trial on a trafficking charge or enter a plea. It's gonna be jail time. So you're gonna come out of the program. So it doesn't really, you know, I mean, yeah, of course you'd rather be out over there at path of grace than in jail, awaiting the resolution of this case or going to the trial. So, based on the seriousness of the charges and, you know, got a break, out on bond, picked up a trafficking charge, bad combination. The court's going to deny the motion to reduce the bond. When's our next case? We're on June 14th.
Thank you, Your Honor. Your Honor, so June 14th. Correct. Kirby Dixon. Your Honor, Stephen Dean with Kirby L. Dixon and 23 CF 816. We're here on a motion for bond reduction. A couple things I wanted to, or maybe 3 or 4 things I wanted to amplify or add that weren't in our motion for bond reduction. To clarify, he does have 4 children. He represents to me that he is paying child support on the 4-year-old, the youngest of the children. He is gainfully employed. He works as basically janitorial services. Yes, and Your Honor, he does have mental health problems. He represents to me. He needs treatment. We'll have him address that in a moment. You know, he's asking for a $25,000 cash or professional instead of the $72,500 cash or professional. Our motion said signature bond, but I did confer with him, and he does believe that he can make a total of not more than $25,000 cash or professional. Can he address the court?
Please raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, so then you are.
Mr. Dixon, without talking about the facts of your case, what is your name?
Kirby Dixon.
Do you have some mental health treatment that you've long been receiving medication for?
Yeah.
Would you address the court about that?
Yes, sir. I take 2 shots. I take Abilify and I forgot. It's Abilify and the Abilify and I think
if you can't remember, but would you be willing?
I take 2 shots in each shoulder.
Would you be willing to have yourself on pretrial services that had it as a condition that you would get mental health evaluation, treatment, and take any medications as prescribed for mental health issues?
Yes, sir.
Oh, do you pay child support on the 4-year-old?
Yes, sir.
And you work with at your mother's school as a janitor, is that correct? Is there anything else that you wanted to tell the court without talking about the facts of your case?
Just that I'm a good person. I made a bad decision.
Don't talk about the facts.
Okay. And I was hoping that maybe you could help me out on the bond reduction so that I could see some light. I hope you have mercy on me, Judge.
And you're not getting the medication?
I'm not getting the medication there. They're not giving me the shots in jail. As a matter of fact, they're not giving me anything except high blood pressure medicine, and that's making me pass out.
Nothing further.
Mr. Medina, just for the court's knowledge, what is the situation when you have medication that he's prescribed? They just make an independent decision not to provide it?
The jail has custodial responsibility. They have a medical staff, and I can't address the particulars other than that they're responsible for providing needed care, and we don't have any civil recourse with the public defender's office on anything like that. We do, however, routinely bring that to the court's attention in the context of bond, because many times it's not uncommon that people have mental health issues that needs to get addressed that isn't being addressed. I'm not saying it's a good thing, but I just don't think there's any jurisdiction that I'm aware of in this particulars to demand his particular treatment. Please.
So, Your Honor, in this case, it is alleged that Mr. Dixon was involved in a retail theft. Upon going to the jail, there was drugs discovered on his person. There was a trafficking amount of methamphetamine, and a trafficking amount of fentanyl. And then there was also some MDMA on him, Your Honor. So that's why he has so many charges, given the multitude of drugs and the fact that he got all the way to the jail with it. The state believes that the bond that he has currently is appropriate, given that there are 2 trafficking charges here. And
Does the state have an offer on the table?
the minimum mandatory for the trafficking.
Which is?
Just a second.
Do you want to see your score?
And if you
Yes,
can
Your
inform
Honor.
the court about the history of this defendant by way of drugs in the past.
So there's a 3-year minimum mandatory on the, I believe that's a fentanyl charge, and then there's a 7-year minimum mandatory. I believe that's the methamphetamine charge, Your Honor. So the state was asking for 7
Is
years.
this one of these a fentanyl?
I think you may have reversed that. I think count
Yes.
2 is alleges fentanyl. Your Honor, I think it was a possession situation because of maybe some slight exceedance of a threshold. It turns it into a whole other situation. I think that I'm not trying to cut the Ms. Sharpless off, but I do know that he would be probably well served through dual diagnosis, evaluation, treatment, not simply mental health, to assure that any substance issues are being addressed as well. I'm sorry to cut you off.
So, Your Honor, the state does believe that the bonds is set are appropriate.
What's the history here?
Your Honor, there were some out-of-state misdemeanors. There were some other things on his NCIC that I'm trying to get certified judgments for, but I believe the score sheet showed 3 out-of-state misdemeanors.
And Your Honor, because he does have, your mother lives, is it in Crestview? Where does she live?
Pelham, Mississippi.
Oh, it's in Mississippi. Okay. So, Your Honor, I do think it would be appropriate to clarify that pretrial services could also include GPS. I think that would probably be appropriate given that it's out of state with these charges.
I don't think you can run out of state with the GPS.
We've done it certainly routinely in other cases. Yes.
Not for our GPS in Mississippi?
Your Honor, we'd have to defer to probation or to pretrial services, but I do know in my cases we've done so in the past. There does become a provision that the defendant has to agree to report at certain times to make sure that it's functioning and that the equipment is being monitored. So there are some additional provisions, but they have been able to do it. I would certainly ask the pretrial services they'll be asked about the specific state, but we have done it.
Probation have any just information for the court? I'm interested in.
Yeah, that would be pretrial services on how they monitor. As far as probation goes, it would depend on a transfer to another state and how that state does their GPS search.
You don't really know about pretrial.
I know that in multiple cases, I'm thinking one, Ms. Vaso in particular, and it was an Indiana person. I think it resulted in arrest when there was a problem with the GPS.
So maybe you want to pass it till after the break. You can consult with pretrial services specifically. Then Judge Ketchum would have to answer.
So, what are you proposing specifically by way of a dual diagnosis?
I would propose that, because it's a Mississippi situation, that he within 60 days rather than customary 30 days get a dual diagnosis evaluation. In fact, in your hometown, Mississippi, you'd have to go get an evaluation for mental health and substance abuse issues within 60 days. And if they require treatment, you have to comply with their treatment, including taking medication as prescribed for your mental health issues.
State.
Again, Your Honor, there are 2 trafficking charges here, and the state's not in a position to agree to reduce the bond.
Hey, Mom. How y'all doing?
Your Honor, I just for the record note that his mother and family has entered the courtroom and further signaling that he does have family support from back in Mississippi.
Yes, sir. Thank you, Your Honor.
These are very serious trafficking charges. I mean, the court would agree to reduce this to a total of $50,000, but I'm not going to go below it. So I'll do a slight reduction, and we'd have to split it amongst the. I'll reduce it to. Yeah. 1, 2, 3. Hold on. I've got to split it up now.
Yes, sir.
It'll be $15,000 for each of the trafficking charges, and $10,000 for the smuggling contraband, $5,000 for the possession of a controlled substance, and $2,500 for each of the other 2 charges. Total of $50,000. And dual diagnosis services, I'm not sure exactly what pretrial can do. I mean, that's the kind of thing that we do on a plea agreement, but I don't know exactly what pretrial services can do by way of services.
Your Honor, would he be required to do a GPS?
Yes.
So that's a condition, Your Honor. I do, as an officer of the court, believe that in good faith that it can be done. If we learn that it can't be done, we'll have to come back for clarification.
That's fine.
And Your Honor, the dual diagnosis, evaluation, treatment, the evaluation within 60 days and the commenced treatment within 90 days, so that'd be okay?
Yes, sir.
Your Honor, could I just have his mother identify herself and, just for the record, at the court, given his mental health issues, we've had situations where a parent had a role, but he's obviously an adult. What is your name, Mom?
I'm Reverend Linda Dixon.
Linda Dixon. Okay, what is your address in Mississippi?
I'm 148 Dawson Cutoff
In what city?
in Pebble, Mississippi. And I was earlier given over him to help him stay on track with his medical by one judge in Mississippi. So I've been keeping up with him ever since.
Your Honor, I would ask that the court could also have a condition that mother would, that you would be living with your mom? Is that where you'd be living?
Basically, I take care of him, yes, sir.
You've had a bond hearing. I've reduced the bond
Yes,
slightly. If you've got some additional, it looks like if we're going to do anything more creative,
Yes.
we're going to have to dig into this and figure out exactly what the situation is. It may also impact the final resolution of this case based upon what the condition is.
Thank you for your
So,
service.
ma'am, stay in good contact with the public defender here and figure out where we're going.
Yes, sir. May I please speak just a second?
The court doesn't want any more argument today, ma'am.
Yes, sir. Thank you, Your Honor.
Thank you, Your Honor, for your indulgence.
Thank you very much.
Just to be clear, on the case today, Your Honor, there's his information.
Okay.
And
You're enter a denial, a not guilty on the plea day?
Yes, Your Honor.
Okay, court letter, not guilty. Thank you, Madam
We sent her for the 14th. June
Clerk. And the
14th.
next court, that's good. That's it.
So it's all we discussed was the time.
Yeah, like 5,000.
Yes, Your Honor, June 14th pre-trial. Thank you. Your Honor, I'll talk to the family. Thank you.
We have a private attorney in the gallery, Your Honor. I don't know if he's ready to go.
Counsel?
Yes, Your Honor, that's Thomas McGuire. I'm going to wait till the end because we might have a long hearing.
Well, you can come up here now. We aren't going to have that hearing because it wasn't supposed to be set in the morning. Whoever said it in the morning shouldn't have said
Well,
it.
Your Honor, this was one that was set this afternoon, and because there were so many arraignments, Ms. Van Boxtel moved it to this morning.
Well, I'm fine to move this wherever the court feels it's appropriate. I'm not-
How long is the hearing?
Your Honor, I think it'll take 20 or 30 minutes. I don't think it's going to take.
I'm sorry, Your Honor.
No, that's all right. We're just trying to, we have certain things in the afternoon and we had an unfortunate cancellation of an afternoon docket through no fault of anybody in the courtroom. And it kind of threw everything off and we've been trying to kind of get back order. We'll try and do it later this morning.
Thank you very much.
We'll try and do it later this morning. Let's get all these cases on the way. Okay. So, Mr. Morrow, you want to?
Certainly, Your Honor. The rest of mine are inmates.
Okay.
Which one's yours and the left one?
Let's start with Mr. Alloway and then to Mr. Ard. Mine are the last 8.
Okay, Alloway first.
Okay, thank you.
We're ready for Ms. Alloway for the case.
Okay.
all the way to the left hand, there are the attorneys.
Ryan Morrow, Mr. Ron of Alloway, Your Honor. This is 1657. I've been presented with the state's offer to contemplate a guideline sentence. The issue from the defense perspective is I think there's maybe some issues with the score sheet, the underlying score sheet and the current score sheet. I'm going to ask to continue.
Mr. Morrow, would you try and speak into that mic?
Oh, I'm sorry.
That's all right. I just want to make sure and hear you.
Of course. I'm asking this matter to be continued to our next date. I don't think I need all the way until 6:20, but the issue that I have is I'm double booked in front of Judge Brown and Your Honor on 6:15, so I'd ask that it not be 6:15.
6:20, 9 a.m.
Thank you, Your Honor.
Without
And he did say denial, right?
If there is not already a denial on the record, we'll be entering that. I'm
Court will enter
sorry.
the denial. Thank you.
Thank you, ma'am.
Right this way.
And next on my list, Your Honor, will be Mr. John Ard.
Mr. Ard?
Ryan Morrow for Mr. Ard. Your Honor, this is 21 CF 1037. This is a VOP. We're going to be entering a plea to the court. I've prepared some paperwork. It is going to be a plea to the bench. I just want to put on record that he has 15 charges. Each one are third-degree felonies, represent a maximum of 5 years state prison times 15, Your Honor. Plea to the bench, no agreement from the state, but it is my understanding there is a 5-year suspended DOC sentence. And we will be waiving the pre-sentence.
I'm sorry, say it again. You said something about
A 5-year suspended sentence on the case, Your Honor, is my understanding. And speaking, we don't have Mr.
Is what? I didn't understand what you're saying. You said about a 5.
Right, I just wanted to make the court aware.
Are you saying that's an offer?
No, Your Honor. That was
Not
in
following.
I'm sorry. Let me be clear. When he was sentenced initially in this case, it's my understanding that he currently has a 5-year suspended sentence. I just wanted to differentiate between
Who's handling this case?
This is Ms. Bossow's case, Your Honor.
Ms. Boss out here?
No, Your Honor, but I'm...
I need to ask a question.
Certainly.
My question is, does the suspended sentence limit?
I believe it does, Your Honor, would be my position. I just wanted to differentiate between the statutory maximums and the suspended sentence.
Okay.
Shall we wait for the state on this matter, or are you comfortable taking?
Unless somebody can speak for Ms. Bossow as to the agreement of this case, yes.
Well, there isn't an agreement. This is going to be a plea to the bench, so we'll have argument on the sentence, but I just wanted to make the court aware of that.
Okay, so are you entering a guilty plea?
Yes, Your Honor, to the VOP. And we're going to ask the court to set sentencing. I think 620 would be fine.
I would rather have the state.
I'm fine with that, Your Honor. I could call my 6 other cases. Yes, Your Honor.
Okay. Where is she going to be coming back?
She should be right back, Your Honor.
Okay. Just hold on. We'll bring her
Absolutely,
right
Your
back.
Honor.
Right this way, Mr. Ard. Mr. Ard, right this way, sir. Sean Bildstein? We need to hold Mr. Ard. You can probably just keep him in there.
Ryan Marr from Mr. Bildstein, Your Honor. He's been presented with the state's offer of 20-month state prison. I'm asking the court to place us on 620, and we'll come back with either a resolution or a plea to the bench at that time.
Very good. We'll continue this final continuance to June 20th at 9 a.m.
Right this way, Mr.
Thank you.
Jose Booney?
Ryan Morrow for Mr. Booney, Your Honor. The defense is requesting that the court put us on 620. I'm going to have Mr. Booney evaluated for some treatment courts as well as some inpatient treatment options and have a psychological evaluation conducted before that time. he was placed today for potential resolution. Unfortunately, the state is seeking the imposition of a 40-month state prison sentence.
Okay. Court will continue this till June 20th at 9 a.m. I assume that's the last continuance, or will either be
Understood,
set?
Your Honor.
Court will note that for the minutes, please. Thank you very much.
Israel Chartrand.
Ryan Morrow for Mr. Chartrand, Your Honor. This is 22 CF 2721 and 22 CF 3012. We're asking that this matter be set for an evidentiary hearing. If 620 is not getting backed up, that date would be fine.
How long do you anticipate needing?
This one may be a little longer, Your Honor. Maybe an hour, could be a little bit longer depending on how much testimony and how much argument.
Generally ask.
I know. The problem is, Your Honor, is the information I intend to utilize I do not yet possess, so it's hard for me to say at this juncture. But I wouldn't venture to call this one of my shorter ones just because I have an idea of what it's going to entail.
What do we have?
Your Honor, you have 4 scheduled in the afternoon for June 20th, but 2 days later at 1:30, where you don't have an arraignment, you don't have any cases scheduled yet.
So we'll set a trial for June 22nd at 1:30.
Thank you, Your Honor.
Joseph Hopkins.
Ryan Morrow for Mr. Hopkins, Your Honor. Mr. Hopkins, since our last court date, has been denied for Veterans Treatment Court in Keaton, but the nature of those denials have led me to think that he might be a better candidate for mental health court or either Phoenix House or Project Hope. I'm asking the court to put us on 620 so I can have those evals conducted, Your Honor.
State okay with that?
This is Mr. Joseph Hopkins. The state is fine with that.
Court will continue this till June 20th at 9 a.m. without subpoenas. I have 108 of Ramaya Custer.
That is a plea, Your Honor, but that's his boss. That's the case, so I was holding that one until she returned.
Okay.
This is Mr. Darren Taylor, Your Honor. He has 4 matters before the court: 19 CF 2910, 21 CF 250, 22 CF 1746, and 22 CF 2182. May I step away and advise Mr. Taylor of something, Your Honor?
Sure. Are you bringing her up to speed on the case that we had?
I am
Explain to her about it. I'll bring it back out. Bring it back.
Ryan Morrow for Mr. Taylor, Your Honor. I had just received the state's offer this morning. I just advised him of that. I'm asking for 620, and at that time it will be either a plea to the state's offer or a plea with court.
Very good. The court will continue to 6:20 without subpoenas at 9 a.m., and that'll be a last continuance. Clerk will fill that in.
And we do have this process back in court.
Right. So let's go and bring that back out.
Is that Mr. Ard?
Yep, Mr. Ard.
And back on the record with John Ard, Your Honor, 21 CF 1037. This will be a plea to the bench.
And he did, the defense mentioned this suspended sentence.
Yes, Your Honor, the state is going to be asking to vacate that sentence and impose it in return for the violation of probation. He agreed at the
That's
time.
what I'm trying to think.
Right.
That's why I wanted her here, because you just said that you thought that put an upper cap on it of 5 years. That's why I was raising this issue. And sometimes, without vacating it, it puts a cap on a plea to the bench, right?
Your Honor,
It would.
Your Honor, our understanding is if at the time that he entered the plea, he agreed to a suspended sentence, that if he violates it, then that would be his maximum for a violation of his supervision, not if there was a new law violation. So our understanding is that it would be a 5-year cap if it's only a technical violation, which I believe Mr. Harden said that he has.
Okay, and that's what I was trying to clarify. So it is a cap.
It is as
You
it
said
is.
you were going to remove.
Well, we're asking that it be vacated and imposed. Different people use different terms.
Okay.
We're just asking the court to impose it. That'll be
But
our
that would have the effect of having a 5-year cap on this plea.
Yes, sir.
Okay. I just want to make sure everybody's clear about that. I didn't want them to think that it was a 5-year cap and you be arguing that it was not. It was a 75-year cap, which is what it is, total amount or whatever, some large amount, 60, 45, whatever.
And the cap, Your Honor, of course, is only as to any incarceration terms. It would not be as to any probation.
I'm trying to think of where we left off, Your Honor, but the
Why
only
don't you
thing...
start over?
Understood. This is John Ard, Your Honor, 21 CF 1037. We're here to enter a plea to the bench. The state has mentioned the cap. The court has mentioned his maximum of 75 years based on the statutory maximum for the charges.
What's actually not? What's 15 times 5? 15 times 5 is 75.
The only other thing I want to put on record before handing this off to the court is that we are, if he is entitled to a pre-sentence investigation, we are waiving that, Your Honor. And the state asked that Mr. Ard agree to that before.
Why are we waiving the pre-sentencing investigation?
Your Honor, that would be the defendant's request, not the state's.
That was just advice of counsel, Your Honor, and Mr. Ard agrees. There's no other reason than that.
I want a pre-sentencing investigation.
The court wants the pre-sentence. Okay, understood.
I want as much information as I can.
Understood, Your Honor.
It's a serious decision on Mr. Ard's behalf that I have to make, and I want to make sure I've got all the information I can. Make sure
If he's only
give a
waiving
fair
his right to
sentence.
it, if the court orders it, I don't believe there's anything I can do about that.
Okay.
I'll pause to give Mr. Ard an opportunity to sign.
How long do you all need for that?
Your Honor, we would request 40 days.
So, let's see. July 18th, maybe, and July 13th, Madam Clerk, as far as in the afternoon for sentencing. I'm sure there'll be some testimony or some arguments.
Just some testimony from my client, Your Honor, from my
But
perspective.
it'll be more than just a morning docket of more than 5 minutes or 10 minutes.
A little bit more, Your Honor.
Yeah, I know it won't, it's not necessarily lengthy.
So on your sheet, you show July 13th.
I do on this, if that's not correct.
Yes, on my sheet says July 11th. So that's something that I'll need to look into.
Are we both on the same page on July 18th?
Yes, sir.
Okay, so let's do it on July 18th in the afternoon.
Yes, sir, 2:30.
2:30.
May I approach, Your Honor?
You may. Mr. Ard, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? I do. Okay. So you heard there have been some discussions on this, but I just want to make sure that you're clear and you're entering this with knowledge and free and voluntarily. So I see you signed the violation of probation plea agreement. Have you read this plea agreement closely? Have you gone over it in detail with your attorney? Make sure you understand all the legal ramifications.
Yes, sir.
you understand that by entering this, you're waiving the right to go to a contested hearing and have the state prove their case and other valuable rights. You believe it's in your best interest to do that?
I do.
And this is a plea to the bench, and there was some discussion about that because you had a previous a suspended sentence of 5 years. That's the limit on the incarcerated portion of this. But there may be some other things, probation, other requirements on this. Do you understand that beyond the 5 years?
Yes, sir.
And you understand that by entering this here today, barring some unique set of circumstances, this limits your ability to back out.
Yes, sir.
Very good. Based upon that, the court will accept your plea here today. It'll be a plea to the bench, and this will be an adjudication of guilt, and will be adjudicated here today. So adjudication of guilt, discretion, is that what we want?
He was previously adjudicated in the underlying case, Your Honor.
Okay. So it's not the discretion of the court.
No, he's previously adjudicated, Your Honor. That should have been prior adjudication.
Your Honor, I think counsel may want to discuss public defender's colloquy a little bit. Do you have any additional information?
I was just discussing that with Ms. Bosco, Your Honor. I think the court is limited on 5 years of incarceration and or probation. There can't be 5 years and then probation to follow. We just recently had that issue in one of Mr. Medina's and Ms. Taylor Sharpless's cases.
The total of 5 years,
Your Honor, the state has no reason to disbelieve what Mr. Gates has brought to the court's attention. We'll just double check it before we actually go to the sentencing hearing. If there's anything different, we'll make sure both parties are aware.
Well, the defendant but he accepted the plea based upon that. But the bottom line is, legally, you might or you might not. There may be a disagreement, in which case it will be brought back before the court of whether or not. So I made a statement that may not be accurate. That there may not be, if I give you 5 years incarcerated, I may not be able to give you additional probation. That's what the discussion is. But that'll be argued legally. But you're pleading that to the bench, and I'll make a ruling based on what the law is, and you guys will make sure and help clarify that.
And Mr. Gates has raised that with me as well, and I certainly, as Ms. Bosco, I want to look into that and make sure that I'm correct before I argue here today.
Very good. I appreciate that, Mr. Gates.
Yes, sir.
To get that, those kind of details are very important. Okay. Very good. Anything else? Counsel?
Not from the defense, Your Honor.
Thank you very much.
Jeremiah Custer.
And I do have a score sheet for you, actually. So Ms. Custer? That's the DOP score sheet. From my video.
This is Ms. Ramaya Custer, Your Honor, 20 CF 1039. We're going to be entering a negotiated plea on the VOP. The agreement contemplates that we'll be asking the court to reinstate and modify their supervision 45 days as Okaloosa County Jail with credit for all time served, convert the remaining balance of supervision to drug offender probation, 7 to 7 curfew, twice monthly drug testing, and to complete a substance abuse evaluation and follow all recommendations, $100 VOP fee, $150 cost of defense. We will be asking the court to continue to withhold adjudication on the underlying charge. I'll pause and give Ms. Custer an opportunity to sign. And the state has provided me with a score sheet and approach for that.
That is the state's agreement, and the 45 days, the county jail will be as a condition of probation, so we believe it's appropriate to withhold, to continue to withhold.
May I approach, Your Honor? No objection to the score sheet.
Thank you. So, Ms. Custer, would you please raise your right hand? You swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God.
Yes, sir.
Hey, talk to me that mic for me.
Yes, sir.
Thank you. Ms. Custer, I see that you have signed the violation of probation plea agreement. Have you had a chance to review this plea agreement closely?
Yes.
And have you had a chance to go over it in detail with your attorney to make sure you had all your legal questions answered about this plea agreement?
Yes, sir.
And you understand that by entering into this plea agreement here today, you will waive some valuable legal rights. The right to go to a hearing, to contest this, to make the state prove their case. By doing that, in exchange for all that, you're going to have a final resolution in this case as contained in this agreement. You understand that?
Yes, sir.
You believe that's in your best interest?
Yes, sir.
And nobody coerced you to enter into this?
No, they did not.
Very good. Based upon that testimony, the court will accept the plea agreement. The court will reinstate and modify supervision. And as a condition of the supervision, the court is sentencing the defendant to 45 days in the Okaloosa County Jail. You will receive credit for all time served and will convert the remaining term of the probation to a drug offender probation that has specific additional terms, curfew, twice a month drug testing, substance abuse evaluation, follow recommendations, etc. All that are contained in this. The one thing I want to make sure that, and this is a withhold, I want to clarify what Ms. Bossell said, that the 45 days Okaloosa County Jail is a condition of the probation. And we're doing this so she can continue to withhold rather than have her have an adjudication for your benefit. So I'm going to let you just make sure and just clarify that.
I will.
I'm sorry. Probation.
Your Honor, we would request that probation could modify the curfew for work purposes.
Yes, that is correct. And probation just raised something that probation does have the authority to modify the curfew.
Yes,
to you know, if you have some, if you're working at a night shift or something for work.
Yes, sir.
Okay, anything else? Thank you very much.
Dominic Goodson for Mr. Harper.
I believe that's all I have this morning. Your Honor, may be excused. Thank you.
Just one moment, Judge. All right, so one of these. Everything's the same. We just have to make sure it's so if it's on. Thank you, Judge. I believe that we've addressed the issues. This is Dominique Goodson, 22 CF 1027 and 22 CF 1019. This will be a plea to a lesser included offense of misdemeanor petty theft and 22 CF 1019 count 1. The state will announce a no process to 22 CF 1027 count 2 and 22 CF 1019 count 2. To be adjudicated guilty, given credit for time served, to run concurrent, be assessed court costs, costs to be paid within 180 days or sent to judgment, and there is no action on the failure to appear. This is a plea to just misdemeanor, so there's no score sheet of manipulation.
Stated agreement.
That's correct.
Thank you. Okay, good. Just make sure So, Ms. Goodson, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
When we're dealing with your rights and responsibilities under this, it's important that we get these details correct.
Yes, sir.
For your benefit and so everyone's clear. We don't want, you to think you're getting one deal and you're something else at a later time.
Yes, sir.
A lot of this, as you know, with all these statutory, all the laws and stuff can be very detailed.
Yes, sir.
So you heard your attorney state the terms of the plea agreement. And slight change from earlier, they're actually reducing one of the charges that actually end up being 2 misdemeanor charges. And the other 2 charges, the felony charges, are being dismissed. Okay? You have 2 misdemeanor charges that you're pleading guilty to. Those are count 1 of each count. 1 is a lesser included count. And you will get an adjudication of guilt on these 2 charges. And you'll get credit for time served, and they'll be concurrent, so they won't be stacked on top of one another. Got some court costs and fees that will be paid within 180 days, where you'll be sent to judgment, and then the failure to appear will be kind of thrown out of court.
Yes, sir.
Okay, is that your understanding what the plea agreement is?
Yes, sir.
And you understand that by entering into this will be a final resolution of this case?
Yes, sir.
You waive the right to go to a trial and a hearing. You believe this is in your best interest to do this?
Yes, sir.
Okay, you have any questions?
No, sir.
Thank you very much.
Thank you.
Judge, I do have one more in custody.
The court will, as the FTA was not served, so the court's actually withdrawn yet.
Thank you, Judge.
Thank you.
But I'm almost done with the plea agreement. If I can continue to pass, I'm sure there's.
That's fine.
I do not.
Yes?
Yes, Your Honor. I'm already on my 1 hour custody, and then I can take my inmates.
Okay.
Your Honor, if I could call Miss Tony Hazelwood. This is Miss Hazelwood approaching. We left her as a status for today. We do have a plea agreement to be filed on her case that will be covering both cases. If I may approach, Your Honor.
You may. Could you please announce?
Yes, Your Honor. Ms. Hazelwood will actually be entering a plea no contest as charged in both cases. It's 21 CF 1412, 23 CF 136. In the term specifically, she will only be adjudicated on the paraphernalia charge, which is count 3 of 21 CF 1412. All other counts and cases will be a withhold of adjudication. In 21 CF 1412, count 1, the felony count should be placed on 24 months of probation concurrent. In counts 2 and 3 should be placed on a year of probation concurrent. Waive costs of supervision, $615 in court costs, $150 public defender fee. Required to do a substance abuse evaluation within 30 days. Any recommended treatment within 60 days. Random analysis. And then 23 CF 136. 24 months of probation concurrent, waive costs of supervision, no contact with Miss Alyssa Trimble, no trespassing at 3146 Forest Avenue, Crestview, Florida, 32539. She originally was asking to transfer probation to Alabama, but she's no longer seeking that, so we don't need the court to address that issue.
Okay.
All that is correct, Your Honor. However, I am seeing a problem with my score sheet, so I'll give you a score sheet after this.
Okay. Is that okay?
Yes, Your Honor.
Okay. So, Ms. Hazelwood, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Just need to ask you a couple questions, make sure you understand what you're doing here and you're entering into it freely and voluntarily. So you heard your attorney state the terms of your plea agreement, and I see that you have signed this plea and sentencing agreement that also contains your terms. First of all, did you read this agreement closely?
Yes, sir.
And have you gone over it in detail with your attorney? Make sure you understand it's got a lot of legal stuff in here it's contained.
Yes, sir.
Have you gotten all your legal questions answered?
Yes, sir.
You understand that by entering into this plea, importantly, you're waiving some valuable legal rights, the right to go to a hearing, the right to force the state to prove their case, etc. This will result in a final adjudication of this case. Now there'll be a withhold of adjudication on all your counts except the one misdemeanor, count 3 of 21 CF 1412. That'll be an adjudication of guilt. You'll be sentenced to 24 months probation on count 1 of 21 CF 1412. And then the other counts 2 and 3 You'll have a year of probation, basically 11 months, 29 days. Will be served concurrently, so 2 years probation is the key. And then the other case is also 24 months probation, again concurrent, which means they're running together. So it's basically a total of 24 months probation. Okay. There are a number of additional fees and costs that are contained in here, plus importantly substance abuse evaluation and treatment. That's a condition of your probation. So you must complete that as a condition, or you would be violating. You could come back in here and be sentenced, etc. So, in addition to that, and importantly, the no contact with illicit trim. Okay, so one-sided contact. I don't know any of the circumstances, but you need to stay away. Even if she walks up to you or calls you on the phone, you're in violation. She's not. So stay away, and stay no trespassing on the Forest Avenue address that's contained. Any questions? Okay. Thank you very much. Good luck.
Just in order.
Jeffrey Felton?
Felton.
Felton,
You doing this? Your Honor, this is Mr. Jeffrey Felton before the court. We left him as a status. We do have a plea agreement to be filed in his case. May I approach, Your Honor?
You may. And Your Honor, I do have the score sheet. May I approach as well?
You may. Is the defense okay with the score sheet?
You got no objection to score sheet if I may approach.
Thank you. Please announce the plea.
Yes, Your Honor. Mr. Felton will be entering a plea of no contest as charged. He'll be adjudicated guilty, sentenced to 6 months in the county jail with credit for all time served, followed by 24 months of probation. We'll ask the court to waive the supervision fees, $967 in court costs, $150 public defender fee, required to do the anger management course, which can be completed online, undergo mental health evaluation and any recommended treatment, no trespassing at the American Legion Post 235, 105 Hollywood Boulevard, Fort Walton Beach, Florida 32548, and no contact with the employees at that American Legion Post.
Are you staying in agreement?
Yes, Your Honor.
Mr. Felton, would you please raise your right hand, sir? You swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Okay, so Mr. Felton, you heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the written plea agreement that you signed. First of all, have you read this plea agreement closely? Mm-hmm. Yes? Mm-hmm. This is actually being recorded.
Yes.
Okay. So you've read the plea agreement, you've gone over it in detail with your attorney.
Yes.
And you understand that by entering into this plea agreement, importantly, you're waiving the right to go to a trial and waiving some valuable legal rights, confront witnesses, etc. Do you understand that?
Yes.
And that this will be a final adjudication of this case.
Yes.
Do you understand that? And nobody's threatened or coerced you to get you to enter into this plea? You're entering into this freely and voluntarily?
Yes.
Okay. Very good. Based upon that testimony, the court will accept your plea agreement. There'll be an adjudication of guilt, and the defendant will be sentenced to 6 months in the county jail. You will get credit for all time served. It'll be followed by 24 months of probation. Waive the cost of supervision. You've got fees and costs. You must attend anger management course. It can be done online. There must be a mental health evaluation and follow any treatment. Importantly, is the no trespassing of the American Legion. Don't fool around with that, because that'll throw the whole probation in, okay?
Yes.
So stay away from that. No contact with any of the employees with the American Legion. Okay. A little tricky. Let me ask you questions. I don't want him to get tricked up. Does that mean he can't make any contact with employees? What if there's an employee at Walmart and runs into
I think it specifically, the state can correct me, but I think accidental contact in that fashion, I think would be okay. It's direct contact, like going directly there, having direct contact with them would be where we're trying to avoid.
Nobody's going to trick you, but I just want to make sure you're clear about what your responsibilities are, and the state's clear about what those are.
Right, Your Honor, I think Mr. Gates' assessment is correct. I would agree with that. Here, the threats were general in nature to people who are inside that building.
Right.
There was no specific victim here. Okay. So I would say, no going back to that building and having direct contact with employees at that building.
Okay. So just stay away from that, the building there at American. Do you have any questions?
So I literally work less than a block away from there. We drive by there all the time. That's straight. I mean, I work for a moving company. So we're up and down Pioneer Boulevard all the time. So I don't know, maybe throw that out there. Just, I mean, I don't go on the property. I've never even been to the property. So
I think that's what the state's asking for, is not allowed on the property.
Yeah, I mean,
driving.
you have a right to be on a public road, but it can be a little tricky, You yelled out something from the
I'm not going to do that.
from the did, and they took it as a threat. Blah blah blah, and then you end up back in court, and we're arguing over whether that was a violation or not. I want you to be clear. We're not trying to get you into further trouble. We're trying to keep you out. I know it doesn't seem like that a lot.
No, I understand. That's why I actually brought it up.
No, that's a good point. So, I think technically, usually it's 500 feet. You can be on a roadway, but is your work 500 feet? How close is your work from here?
Maybe a better question for probation, because they're going to be the ones instructing him on that.
Put probation on the spot.
I do sometimes, Your Honor.
Well, I mean, unless there's some clarification on the no contact with employees, we would take that as, if he's got contact with one of the employees at Walmart, and they report that to us and sign an affidavit, it would be a violation.
Well, it's not Walmart, it's American Legion.
Right, but I'm saying as far as how it's worded in the plea agreement of no contact with any employees from the American Legion post.
It does say that. I had that same.
Do you want to just say direct contact?
You can say direct contact.
Would that be better? Like accidental contact? How do we phrase it to avoid accidental contact? Like I don't know that he even knows who they are.
And that's the tricky part. So why don't you say no contact at? In other words, employees at. In other words, the contact would have to be at.
I think everybody would be on board with that.
Would that be a little better?
Yes, Your Honor.
The alternative, you could say direct intentional contact with
You're
employees.
going to violate him if he drives past to go to work.
No, the only issue with that would be is if, like what Your Honor raised, is if, they reported that he yelled something at them as he drove.
So I don't think
and the only other thing is, because I'm kind of familiar, I want to make sure that property may be within 500 feet of the American Legion, where he's saying he works, may be within 500 feet. In injunctions, they make it clear 500 feet. A lot of times you guys say no contact, or no trespassing, it's not clear like that.
And I think probation is looking for going on the actual property, not.
Correct.
Okay, good.
Your Honor, I would ask that you put direct intentional contact with the employees. I think that's more specific. It would cover our bases.
And I will write no direct and intentional contact.
That clarifies.
And that should suffice for probation.
Yeah, that's good. Okay, thank you. Okay, any questions, sir? Thank you.
This is Michael Gray before the court in a violation of probation. He's set for arraignment today. We do have a plea agreement negotiated in this case, if I may approach, Your Honor.
You may.
Who is this?
Michael Gray.
Thank you.
Thank you.
Would you announce the terms, please?
Your Honor, this is Mr. Gray before the court. He'll be admitting the violation before the court. He'll be adjudicated guilty. Revoke and terminate his outstanding supervision, 6 months in the county jail with credit for all time served. Standard court costs, public defender fee. Mr. Gray would ask for 24 months to pay those before they're sent to collections. He was previously adjudicated as well, Your Honor.
Very good. Mr. Gray, would you raise your right hand, sir? Swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God. State in agreement with that.
It is, Your Honor, and I know you as court on this case. Thank you.
So, Mr. Gray, you heard your attorney state the terms of your plea agreement, and I see that you've signed a written plea agreement that has the same terms. Is that your understanding of what the agreement is?
Yes, sir.
And you've read through this plea agreement closely and made sure you had all your legal questions answered from your attorney?
Yes, sir.
You understand that by entering into this plea agreement, you're waiving the right to go to a trial and some other valuable legal rights, so there will be a final adjudication of this. You understand that?
Yes, sir.
And you believe that's in your best interest to enter into this?
Yes, sir.
Do you have any further questions?
I just want to know exactly how many days I got credit for.
That's the one thing we can't give you because we don't determine that in jail. So all I can say to you is that you will get credit for all time served, but I don't have the ability to calculate it. And I don't calculate. It's not my, I don't calculate it.
Yes, sir. And he was asking about, and I explained to him, the previous time he spent incarcerated prior to entering the plea to go on probation, plus any time since the most recent arrest on this case, all get counted towards that 6 months.
Is that correct?
Can he say it again?
Yes, Your Honor. Mr. Gray was arrested back in March. He spent about 33 days in jail, entered a plea for supervision, was released. Subsequently violated and arrested on the 22nd of last month, and is now entering the plea this morning. And I explained to him he would be entitled to that credit back in March, April, plus the credit here recently.
So the time he spent on the underlying charge that he spent in the county jail prior to the violation of probation would also be counted credit for time served. That's what he believes in the state.
That's correct.
Okay. We're all in agreement. Okay. Any other questions?
Yes, sir.
Thank you very much.
Look.
Jeffrey Vincent?
Mr. Vincent's before the court in a bond motion. If I can have a second with him. Your Honor, at this time I'm ready to proceed with our bond motion.
Okay, you may.
Your Honor, Mr. Vincent has been in custody for a lengthy amount of time. I want to say October 28, 2021. A lot of that time was spent in Florida State Hospital. Mr. Vincent has recently returned from Florida State Hospital, has been deemed competent to proceed. I've asked the court to consider setting a lower bond. I did speak with his mother, Priscilla Moore, who was present in the courtroom this morning. I would ask the court to set a lower bond and then make it a signature bond with the mother, Priscilla Moore, along with mental health pretrial services. Essentially, what I'm trying to do is get a hold handled that's in Leon County. Mr. Vincent has a hold from an old case. It's a 2003 battery law enforcement case. He's been on an NGI conditional release this entire time. So trying to get that case resolved allows us then to get this cases resolved, potentially in mental health court, because one of the stick-ups we're going to have is that Leon County hold. How do they resolve it? And sometimes that can create a delay in getting them into mental health court. So that's why we're asking the court to do that. I do have some other concerns. The court heard argument this morning from Mr. Medina about medications at the jail. I could tell the court from my experience, when someone comes back from Florida State Hospital, generally given 30 days to 60 days worth of medication. Once that medication runs out, it is entirely up to the jail to make the determination of what appropriate medication should be given and what dosage should be given. A lot of times that may not be the same medication or at the same dosage that they were given. The concern obviously being if he's not given the same medication that got him to be competent, he decompensates and then we're starting the process back over again. I know Mr. Vincent has voiced to myself and his mother some concerns about the medication, not necessarily the mental health medication, but his blood pressure medication. He's been explaining to them they're not giving him the right medication, ask for the right medication, and then they never come back. So he's been without some medication here within the last week or so that he does need. We're simply asking the court to consider all those factors, set a signature bond that his mom can sign him out, kickstart the Leon County stuff. We would have mental health pretrial services to ensure, one, his compliance with any medication as well as any sort of treatment requirements, and allow us ultimately to look at getting him into mental health court as an option.
What's the state's position?
One moment, Your Honor. Your Honor, the state's position when reviewing for this case, I looked at the docket in 4621 CF 002780, and in the docket entry on November 1st, 2022, it's very clear that he picked up this second charge while on pretrial release and pretrial supervision for the first charge, which was the case number ending in 2861. Because of that, the state does not believe that he should be eligible for a bond, and that's why he's being held under a bond at this time. In addition to that, I would note that the second offense that he picked up was more severe than the first offense, which shows a pattern of escalating behavior, which I think is concerning, and this court should certainly consider when evaluating this motion for bond reduction. The new charge that he picked up was a burglary of a dwelling with a battery, which is a first-degree felony punishable by life. This is a very serious crime, and although I'm not prepared today to talk about medications at the jail, I noticed that that's not mentioned anywhere in the motion. So, Your Honor, at this time, the state's position is that he should not be eligible for a bond on that second charge.
Yes, Your Honor. And if the court was to review the court record for that new charge in the 21 CF 2780, the court would see that in less than 60 days, or about 60 days from the arrest, he was deemed competent at Florida State Hospital. Again, he's got a 2003 case in which he was deemed not guilty by reason of insanity. Clearly, at the time of the offense, it's more than likely Mr. Vincent was not guilty by reason of insanity. The whole point of spending the last year in Florida State Hospital as well as the jail was to try and get him to a competency level, to get him to restore to medication, which is where we're at now. My concern is ultimately if we keep him in custody and he does not get the right medication, he decompensates.
How would the medication work if he's released? In other words,
and that's
how do we make sure that whatever medication, assuming it's appropriate medication, that made him competent or allowed him to be competent at Florida State Hospital is continued?
And that's where two things. One, mental health pretrial services comes in play. Part of their program does require them to, one, keep treatment and stay on medication that's prescribed. They also have the ability to help assist with that. Second part is, I know the court's aware of John Barnes, the mental health coordinator, kind of for the court system. He and I have had conversations, and typically what he does is he tries to assist in that gap from when they're released from custody to when they can get into the doctor to get the treatment. He tries to help make sure that they do have appropriate medication, that there isn't enough to try and tie them over. He and I have also had that conversation about trying to make sure that they stay on the medication, because we don't ultimately want them to come back like Mr. Vincent did here when he was really straight without that option. Those are the only kind of answers I have, is when we can make sure mental health pretrial services make sure he stays on medication. His mother is also present, who would make sure he stays on that medication. And two, I would ask Mr. Barnes to assist in getting him into treatment sooner and making sure that he gets the appropriate medication when he is ultimately released from custody, if the court was inclined to do that.
State, will you comment?
Your Honor, I'm not in disagreement with Mr. Gates regarding the fact that if the court sees fit to assign a bond in the second case, I would say that that bond needs to, a condition of the bond needs to be mental health pretrial services to ensure that he doesn't get out and run into the same problems that are being expressed that he might run into at the jail, meaning that he simply not taking medications and decompensating and we're stuck in the cycle. So, of course, if the court sees fit to grant a bond, I would ask that mental health pretrial services be a part of that process. However, it is the state's position that a bond is not appropriate in this instance.
Court's going to allow a bond. Mr. Vincent, I am telling you that I'm taking a chance. I'm overriding the state's arguments in order to give you a signature bond. So what's most important is that you work closely with pretrial services, which is what the mental health portion of pretrial services, so you can stay on your medication, so you can feel better and stay straight. Okay? So the court is going to issue signature bonds of $5,000 signature bond with each of the two charges. And I've got is there just two, or you've got 2020 CF 2801 as well?
I only have before the court 20 CF 2861 and 21 CF 2780.
I know, I see it. I got confused too. In the body of your motion for bond reduction, it has no bond in 20 CF 2801, which is not his case.
I apologize, Your Honor.
The 2801 is not his case?
It should be 2861.
Okay, 2861, got it.
Yes, Your Honor.
Okay, that's good. We just want to clarify it. I thought there might have been a third case out there. I wanted to make sure it was added, so I mean it wouldn't have changed. So the court, for each of the two, for 2020 CF 2860, 2861, and 2021 CF 2780, the court's going to issue a bond of $5,000 signature bond for each of those two. A condition of each of those two is that he would coordinate with pretrial services to get mental health services and to maintain, which is the most important thing, is to maintain the medication.
Yes, sir.
Now, is he going to be staying with his mother?
The hope is that we can get him into a group home that'll help assist with a lot of the medication as well. If the court would be willing to do as a signature bond with Priscilla Moore, his mother.
That's fine.
And a Priscilla, like Priscilla, then Moore. And then mental health pretrial services, and I'll follow the bond order, stay on medication as prescribed as well.
Absolutely. That's maybe the most important.
Yes, sir. And I'll get that order to the state to make sure they're good with it before we file it.
And the reason why I'm doing that is that there was I'm sympathetic to your argument, counsel, for the state, but there was an intervening period of time when he was at the hospital, at the state hospital, and that hopefully that had an impact. And so it seems like that changes the equation just a little bit.
Thank you, Honor.
Okay, thank you.
Thank you.
Your Honor, since you gave the signature bond with his mom, do you want to continue to keep him on the June 14th? Or do you want me to change it to the 12th?
If we can do June the 12th, Your Honor.
June 12th.
Yep, you're right, Mr. Harper.
Judge, we're doing a little bit something that's outside the norm here, and so I just wanted to let the court know the general context in which we're operating.
Okay.
This is actually an older case, notwithstanding the court case number.
Right.
This happened some time ago. He's actually served an extensive period of time in South Carolina, another jurisdiction. There was a hold on him from this county during that entirety of the period. And so what we're doing is we're entering a plea, and he's going to be entitled to that time, and the other jurisdiction in the state stipulates to that. All right, so this is case number 22 CF 1677. This will be a plea to a lesser included offense of robbery without a weapon as to count 9. He'll be adjudicated guilty. Credit for time served as to count 1, which is a misdemeanor. He'll be given 60 months Department of Corrections concurrent as to counts 2, 3, 4, 6, 7, and 8, basically all of third-degree felonies. There are 2 remaining counts. Be adjudicated guilty, credit for time served, and be sentenced to 83.55 months Department of Corrections concurrent as to counts 5 and 9. The state will stipulate to 83.55 months Department of Corrections credit, which has already been served. If I may approach, Judge?
Your Honor, Commissioner Burnett will approach. So.
Store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
An agreement as to this horseshoe.
Yes, Your Honor.
And is not a downward departure?
It is not.
It is not a downward departure.
Now, at the bottom you say which has been served. Are these, all of these have been served?
Yes, Judge.
Yes.
Okay. Mr. Brown, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
Okay. You heard your attorney state the terms of the plea agreement?
Yes.
And I see those same terms are contained in the written plea agreement. You can put your hand up. That you have signed. Have you read through this plea agreement closely?
Yes.
And have you gone over it in detail with your attorney to make sure you understand the terms?
Yes.
Importantly, you're waiving some valuable legal rights. Rights to go to a trial. And this is a complicated case because there's been a lot of water under the dam. You've served a lot in another jurisdiction. You're getting credit for time served. As a matter of fact, even though there are some substantial incarcerative sentence you're being sentenced to here today, you're getting credit for time served that's more than that. So you basically can get out, correct?
Yes, Judge. He's served actually in excess of that 83.5.
That's correct, Your Honor.
And the same thing with regards to the 60 months? He's getting credit for time served there as well, right?
Yes, sir, that's concurrent.
He has
That's
been,
concurrent.
he was brought back to our jurisdiction just recently, but prior to that, he had been in South Carolina since this 2009 incident, and that's why we had a hold on him. So he served 10 plus years in South Carolina.
But there still will be an adjudication of guilt, and are there fees and costs are not contained in here? Standard fees and costs?
Yes, Judge, and we've asked
Direct collections?
Yes, if we can set that to judgment. He's anticipating being employed by his family. His family traveled from Tennessee to address his return, and if we can set those costs to judgment, to set them to give them 180 days to pay them, otherwise it's a judgment.
Okay, very good. So standard fees and costs, 180 days to pay, or goes to judgment. They'll be delineated in the actual order. So, and again, there'll be 60 months. Department of Corrections concurrent as to counts 2, 3, 4, 6, 7, and 8. And then 83.55 months in the Department of Corrections for counts 5 and 9. All of them are served concurrent, and this would actually mean that he's served more time than all of these. He'll be able to get out of jail. Okay. Any questions? Okay. Any questions, sir?
All right, this way, Mr. Cross.
Thank you, Judge. That's all I have this morning.
Thank you. I think that's all of yours, Mr. Gates. Mr. Medina, I have one of yours.
I'm not sure who that is, Your Honor.
William Lowe for status conference.
Right, that's the gentleman that we had a status conference before. He's the gentleman who's over in I think it's a Santa Rosa County facility, a private facility.
I'm not sure where
Yeah.
it is, but
Let me.
Your Honor, this is a
I had
status.
a question mark myself, wasn't exactly sure what we were.
Yes, Your Honor, it's a status on Mr. Lowe's case. This was the case where Your Honor sentenced him to a suspended sentence followed by probation. Mr. Lowe then did an appeal. The state stipulated that the sentencing order should be corrected to remove the followed by probation piece. But the court's question was, does Mr. Lowe need to appear to appear because the court would be amending the court order, and is it a ministerial act versus is it a really resentencing? Your Honor, the public defender's office and I agree this is a ministerial act. And Mr. Lowe's unable to be transported today from what Mr. Medina emailed yesterday.
I don't know about, I mean, basically, Your Honor, all I can report is that I briefed the issue for the court. I felt, based on my understanding of the case law, and I advised the court in the memorandum of law that I didn't think he had to be transported because it was exactly offering, would be granting what he'd been requesting, and that our efforts to schedule an appearance by Zoom were unsuccessful because of lack of response back from the facility that he's in. We didn't want to seek an order to transport because that might adversely affect his gain time.
Okay, so this is it's a technicality, but it's an important technicality because there are some rights to be present at certain key points in criminal proceedings. I just want to make sure we were not in violation of that. And based upon your research, if you don't disagree that if it's deemed a ministerial act, that it doesn't waive the requirement, but it's not necessary for the defendant to be here present. And so as long as the defense states to the court that they believe that's the state of the law and that you're not opposed to the resentencing, the correction to be done without his presence, the court will waive his presence and we can get the order signed and get done.
Thank you, Your Honor. For some reason, I don't have the order with me. We'll follow up with an appropriate e-filing of that later today. I'll make sure that we do that, Your Honor.
Very good. Okay.
Thank you.
I think.
So the motion to correct the sentencing order is granted?
Yes.
Correct.
Okay.
Thank you. Okay. I believe that is all we have on our docket other than Mr. McGuire. Okay. So, Mr. McGuire,
yes, sir.
I've been sitting here for a better part almost 2.5 hours, and after a couple hours, my back starts to hurt, so
I am
I'm gonna take a
withdrawing
short
my-
break, go walk down the hall a little bit.
Go right
We'll
ahead,
come
but
back.
we are
will,
withdrawing our motion.
We'll finish.
She'll be pleading out.
Your Honor, in the interim, I believe the defendant is prepared to take the state's offer. So we do have a plea agreement, but I can.
Oh, you got a plea agreement?
Yes, Your Honor.
Yes, Your Honor. The defense is withdrawing its motion to suppress because the prosecutor corrected me as to what the police report said. I thought it was brake lights, but no, it was the entire running lights, so we're
So,
prepared to plead.
with withdrawal of the motion, if you want to plead, I'll stay around.
Thank you, Your Honor.
Yeah.
We would appreciate that, Your Honor. Thomas McGuire on
So
behalf of...
after that, we're going to go ahead and adjourn. We're not going to do the arraignments, and we'll wait until 1:30. There's some talk kind of pushing through, but we'll come back at 1:30 and we'll do the arraignment.
In case number 2023 CF91, Ms. Caperton was charged with possession of controlled substance, methamphetamine, plus possession of paraphernalia, which was a pipe and a scale. She will be pleading no contest as charged. On count 1, she'll receive adjudication withheld and 18 months probation. Special conditions, $615 court costs, substance abuse evaluation to be completed within 30 days, and any treatment is to begin within 60 days. She is to be subject to random urinalysis. She is to maintain full-time employment or submit 5 job applications per week. She is to complete 24 hours of community service work at a minimum of 8 hours a month. And after 12 months, she may request early termination if there are no violations. On count 2, adjudication withheld, 12 months probation, concurrent, $270 court costs. And that's the extent. If it pleases the court, I'd like to approach.
And did you have a score sheet?
I do. I have the score sheet, Your Honor.
And is the defense in agreement with the score sheet?
Yes, Your Honor, 16.4 points.
Thank you. Thank you.
One last thing, Your Honor. My client actually is on probation in Escambia, and she has recently completed a substance abuse evaluation and treatment. And we're wondering if it's okay with the with the probation department that count toward this probation, would it be satisfactory to the court as well?
When did that occur?
My go was May 24th. I've already had my evaluation, and I have one substance class that I have to take on the 24th of May, and then a mental health screening I've taken, and I have to do one class of anger management.
So let me get this straight. When were you arrested on this charge?
January 9th.
So you were arrested in January, and you want us to take into account the substance abuse class that you took last year before you were arrested on this?
I haven't taken it yet.
I'm sorry?
I take it this year. I just did this.
Okay, so you've done the evaluation.
I just
but you haven't started the treatment. Okay. Stay?
Yes, Your Honor. I was just gonna make.
I just want to make sure I understood what you were asking.
The misdemeanor case that she has in Escambia County, I think, predated this case, and so that's in the interim. She entered a plea. I'm guessing in Escambia County to probation, and I don't know where she's getting a substance abuse evaluation and treatment. Lakeview.
Counseling is a standard provider over there.
I think she'll have to probably sign a release for probation to get that, but they may count it. I'll let probation speak to that. She's doing substance abuse treatment at a place over in Escambia County.
Right. Yeah, as long as the court orders that that's okay, we can obtain that information and utilize that.
Well, the only question I have is that is giving me pause is that the evaluation occurred before this edition. When they do, no?
Let her finish.
Okay, let's clarify this. Give me the timeline of that evaluation versus when this situation occurred?
I can establish that. So she gets arrested in Scambia. It's a charge of stalking.
I'm not worried about what. All I want to know
Then
is.
she gets arrested here. Then she pleads out in Escambia. And just recently, in April, she gets evaluated for substance abuse and is required to do treatment in May now, in June.
I thought you were talking about last year. You got the evaluation. Okay, good. That's fine. You understand my question? I thought you were saying you evaluated before you got arrested this time. This arrest would affect that evaluation if it was done before, but if it was done after, I'm sure they asked you about it, and you said he was arrested over here. Okay. I just need to ask you a few questions to make sure you understand, make sure I understand what all you're pleading to. Would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
Okay. Okay, so you heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the written plea and sentencing agreement that you have signed. Have you had a chance to review this written plea agreement closely?
I did.
And have you gone over it in detail with your attorney to make sure you had all your legal questions answered? Do you have any further legal question about this agreement?
I do.
What's your question?
The community service work. I work a full-time job. I have 3 children.
Mm-hmm.
I'm just curious if
You
if
can
that's
buy
a
it out.
requirement. Yes.
Buyout provision.
Your Honor, the state doesn't object that she can either do it or buy it out. That's fine.
Okay. We need to add this in here?
I don't think so, Your Honor. We can just add, she also buy out at so many dollars per hour.
I think probation's requesting it be in the written agreement.
But it would need to be in there, Your Honor, and also the question would be if she's gonna buy out, there's, in the plea agreement, 8 hours minimum per month. So would she need to pay for those 8 hours that month minimum?
It's 8 hours per month for each of the 18 months? Pretty stout.
Until she reaches 24 hours of community service work. I think the probation officer is saying she has to either do 8 hours or pay for 8 hours every 4.
Yeah, so you can buy them out. You can buy them out at $8 hours a month, or pay for all 24 hours.
Okay.
Community service. What you can't do is you have the 8 hours per month that you've got to do one or the other.
Okay.
I'll put 24 hours community service, minimum 8 hours a month, or if they buy out.
Correct. Okay. So you understand that by entering this plea agreement, this is the final resolution of your case. You're waiving the right to go to a final hearing and contest this matter.
Yes, sir.
You believe it's in your best interest to do that?
Yes, sir.
Did anybody threaten or coerce you to enter into this plea?
Yes, sir.
Anybody promise you anything other than what's contained in this plea agreement?
Yes, sir.
And you believe this is in your best interest to enter into this plea agreement?
Yes, sir.
Very good. Based upon that, the court will accept this plea agreement. There'll be a withhold of adjudication. And as to the possession of a controlled substance, the 18 months probation with fees and costs. Condition of the probation is that you will be assessed substance abuse assessment within 30 days. That's actually already been met. If you've done it for Escambia, and begin treatment within 60 days with random urinalysis, you must maintain full employment or say job applications 24 hours of community service or buy it out. You may request early termination after 12 months with no violations. Count 2 will be 12 months of probation concurrent with standard fees and costs. Any question?
I do have a question. Is there, I don't know if it's possible to put this probation with Escambia County, or will I have probation in 2 separate counties?
I believe you can, but do you hear her question?
Are you
Can
on
she
felony
transfer it to
probation?
Escambia?
Probation.
You're on misdemeanor probation, and you reside in Escambia County?
I reside in Santa Rosa County.
Okay, so you will be transferred to Santa Rosa County Felony Probation Office.
Okay.
But felony and county probation is not.
Okay.
You'll still have to go to 2 different places.
Okay, but I can get transferred to Santa Rosa County instead of Okaloosa?
Yes, after you report to the probation office today.
Okay, thank you.
So report here and they'll walk you through.
Okay.
Okay, any questions?
That's all.
Okay, thank you.
Thank you.
Counsel, anything else for the good of the court here? I think we'll take a little breath and then we'll come back. I know we've got a lengthy arraignment docket this afternoon. Trying to switch around from some earlier cases. Do you want to, we have a number of arraignments today that don't have attorneys. You want to do those first this afternoon, or do you want to try and